Hello, everyone. Good afternoon. Thank you all for joining me today. I have a really great really great conversation. I don't have, I just want to update you guys with certain things that I have seen because knowledge is power. And when you know what's going on, you know how to protect yourself. So, if you join me, please feel free to say hello. And when I'm done with my conversation, I will answer a couple of questions. So, for those who do not know me, and for those who are joining for the first time, my name is Ifeoma Odunlami. I'm an immigration attorney from the Odunlami Law Firm in Cedar Knolls, New Jersey. Our law firm serves clients from all 50 states in matters relating to family immigration, humanitarian immigration, and the like. So, thank you. Um, Thank you, Chev. Yes, I think I'm the attorney on TikTok. There are many attorneys on TikTok, Chev. But I am on TikTok. Hi, Chinedu, thank you for the lady that paid me a compliment. I appreciate you guys. So, um, I really want to talk to you guys about certain things that I have been seeing because it really shocked me, and so I'm just going to talk about it. So, when you get married to a U.S. citizen, right? A green card holder, you're looking as an immigrant, you're looking to get your green card through your spouse. One of the requirements for you to be successful is that you have to prove to USCIS that it's a bona fide marriage. It's a real marriage, that you entered into this marriage for purposes of being with your spouse and not solely for immigration purposes, right? And that burden is on you. So I had a couple of consultations in another case that this happened that made me think that this is something I need to talk to you all about because it's important. So for purposes of confidentiality, I'm just gonna be very general as to the information that I was given. So apparently, this U.S. citizen filed a petition for her spouse. And they've been together for a while, but for some reason, there's always been a problem with the petition because initially they didn't use a lawyer, and there was a time they got an RFE request for evidence. They didn't realize it. They didn't respond. The case was dismissed. They refiled. Just little things here and there. And all these little issues is usually what sends USCIS down the rabbit hole. And when I say the rabbit hole, it's they fixate on something, and you cannot convince them, or they refuse to be convinced that it's a genuine marriage. So now this marriage is very genuine, it's for real, but USCIS for some reason just gave this couple a really hard time. So what happened was one day USCIS went to the US citizens place of work and began to basically accuse her of being involved in a fraudulent marriage and started to threaten her about going to jail, about telling all her family and going to her employer. Remember, she was at work, going to her employer to tell the employer that she's been involved in a sham marriage. And so and then they kept telling her if she didn't withdraw the petition, that she would go to jail. Everybody would know she was involved in fraud. Her employer would fire her. And she got scared and withdrew the petition. And now it wasn't because it wasn't a real marriage, but because she was scared. She was in her place of work. And people are different. There's some people that you can't scare them. They'll tell you, I don't care what you do. You can't come here and threaten me. But there are other people who are, I guess, more, I guess, they have fear. And for this woman, she was at her place of work. She didn't want them talking to her employer in any capacity. And I think that was what really pushed her to just withdraw it. And I think they told her also that she can withdraw it and refile. And it's just the false information they gave her, the threats, it just shocked me to my core, because even people who have been accused of crimes have they have rights. You can't, I mean, even though the police, yes, can lie to a criminal, but if you have an attorney, they're not allowed to ask you questions or do any of this kind of stuff. And this woman had an attorney, and USCIS basically just steamrolled her into withdrawing her petition. And she did, and she thought, well, she'll just refile, but she just needed them to get out of her office because nobody wants to be embarrassed in front of the employer. Nobody wants the employer to know all their business, and that was her choice. But the thing is, it was wrong. It was almost like they bullied her, right? And I've seen this and I've heard this happen where they'll go to either the beneficiary or the petitioner's place of work, or go to their neighbors, or go ask questions and begin to threaten, especially the petitioner, right, with jail time and all that. Now, I know even sometimes when people go for interviews without an attorney, like marriage interviews, and they do a Stokes interview where they separate them, right? I've heard people say that USCIS officers will tell them that your spouse is really married to somebody else and is cheating on you and is lying to you. You need to withdraw this petition. Oh, his real wife is there. They're just trying to, they tell all kinds of falsehoods. And of course, the US citizen gets upset because now she's believing that they must know what they're talking about, that the spouse must be cheating on them, and they feel like they're being used, so they withdraw the petition, right? And I'm all for USCIS, doing their fraud investigation, because that's what they're supposed to do to make sure that marriages are genuine. But to infuse doubt in people's marriages and to lie to people and force them by threats, to withdraw petitions, that's crossing the line, And I've had people who came for consultation who told me that subsequent to their Stokes interview, where the officer told their spouse all kinds of things that were not true, that the spouse, they said, having a lot of problems in their marriage, leading to actual abuse of the beneficiary, where the spouse doesn't believe anything they say, things that when they call their home, they're speaking to their other wife, or their other husband, or that they're cheating. And of course, they become very aggressive because they think that their spouse is cheating on them. And the relationship just goes down the drain, So it's really worrisome. Honestly, this bothered me a lot because one thing you have to know about immigrants is that they have a lot of fear when it comes to their legal status, right? And the things that cause USCIS to become suspicious are things that could be easily explained. For instance, you have an immigrant, a beneficiary who has multiple addresses, right? A lot of times they could have been living somewhere with somebody, and a lot of times they don't want to change their address and give USCIS their updated address because they are afraid. They don't want USCIS to know where they live because they think USCIS is going to come and deport them, which is not true because there's a process. If somebody is going to be deported and you don't have an order of deportation, there is a process, right? But they don't know this. So they give a friend's address because they want to have an anonymity when it comes to where they live. But USCIS sees that and thinks, well, how could you live with this person in this house, but you're also receiving mail in A, B, C, D? That must be a fake marriage. Or I have clients who, in the past, maybe when they filed, they used somebody's address because it was a temporary address, or because somebody was stealing their mail from where they lived, so they use somebody else's address. Sometimes they're very innocent explanations to the things that send officers down the rabbit hole. But I just think it's so wrong to threaten people with go to their place of work, for starters. You don't go to someone's place of work. You go to their place of work and begin to threaten them with telling their employer things that you don't know to be true for a fact, So that was really, 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 really worrisome to me. And so what do you guys do to protect yourself? Well, number one, if you're going for an interview, a marriage interview, you really want to go with an attorney, because when you have a Stokes interview, which is when they separate the couple and ask them the same question to make sure that the answers are the same, if you have an attorney, your attorney will be present when they're interviewing the petitioner, and your attorney will also be present when they're interviewing the beneficiary. But if you go on your own, there's nobody present when, basically you're left at USCIS's mercy, because that's when they get the opportunity to tell your U.S. citizen spouse things that are not accurate and persuade them to withdraw the petition, right? And but if an attorney is there, the attorney serves to protect both of you, to make sure that the interview is being conducted in a proper manner. Because if it's not, your attorney will request a supervisor to come into the situation. So really, you guys, protect yourself. There's this book by Chinua Achebe. I don't know, my Nigerian people I know him, but if you don't know him, now you know. He's like a gifted gifted Nigerian author. His name is Chinua Achebe. He wrote this book called Things Fall Apart. I think I read that book like 100 times, and I've given it to everyone I know, because it's a book about pre-colonial Nigeria and all that, and it's pretty interesting. But what I love the most about this book is that it had a lot of like parables, a lot of sayings that helped me to even learn a lot about my culture, pre-colonial Nigeria. So there's this saying that says that there's a bird called Eneke the bird. Eneke the bird says that since men have learned to shoot without missing, he has learned to fly without perching. So this, I think, is a proverb, basically goes to say, if USCIS is being so aggressive with the way they conduct their interviews, right, you need to come prepared for your interview, right? I can't tell you a lot of people who say that, well, it's a real marriage and I don't have anything to be afraid of, therefore I'm just going to show up. No. You never not show up for an interview. Even if when you're going for a job interview, just because you have all the diplomas in the world does not mean that you don't dress nicely, show up, read up on who is what the job is about. You come prepared. You should always come prepared for any situation, especially when it has to do with your immigration status, because it's so important. And the reason why this really bothers me is because we all know that a sham marriage is a permanent bar to getting a green card. So when these officers play around with people's marriages, telling their spouses things that are not true, they basically lead to a denial of the case based on an alleged sham marriage, which is not true. And so my advice for you guys is just make sure that you are on top of your petitions. Make sure that, and honestly, if you in immigration, you have an immigration process and you change your address, it's really important to update USCIS. I know people are afraid of being deported, but really, because sometimes that really comes to hurt you if they feel that you don't live with your spouse. Okay, so I give you guys a lot of information, and so make sure you're following me. I give you this information because knowledge is power. I want you guys to know what is out there, and I want you to be prepared, and I want you to show up with your best information so that you can can get your papers. So that was what I wanted to talk about, but I wanted to also talk about one great success story we have. We have so many, but I remember this case because I did a consult, and I remember how tearful the client was, and now she got her green card. So let me tell you what happened. And I'm going to have to read some of it because I'm looking at my notes. So my client's spouse filed for her sometime in 2014, right? And she received a request for evidence to show, she had to prove how she came into the United States. So this is what happened. She came to the United States on a passport from another country, not American passport, not a fake American passport, because you guys know also that's a permanent bar. There's no waivers for using USCIS passports to commit fraud. So she came in with a passport from another country, say it was Ghana, but and a fake name. It wasn't her name, and she had a visitor's visa in it, and she came in with that. So subsequently, she got married to a U.S. citizen, right? And U.S. citizen filed for her, and U.S. citizen spouse filed for her, and the case was denied because she couldn't prove that the way she came in, because she came in with a fake passport. She came in with somebody else's name, and you all know that if you can't prove the way you came in, you have to you may not be able to adjust your status because you can't prove that you had a legal entry. And of course, in her case, if you came in through using a fake document or using somebody's passport or anything like that, you're going to have to file a waiver because you got to be forgiven for that crime, okay? Because that's immigration crime. And to get a waiver, you have to prove that your U.S. citizen or green card holder spouse or parent, if you have one, will suffer extreme hardship if you were not allowed to stay in the country. So that's what she had to prove. So she went to this attorney, and the case was denied because she couldn't prove that she got in legally, and then for some reason the attorney filed a 601, I guess, which is a forgiveness. That was denied as well because 601s, all those kind of waivers, they're really they're very discretionary, right? There's no right to it. You have to present a compelling case. So the attorney filed that, it was denied. The 485 was denied. The 601 was denied. They filed an appeal that was denied. And then they came to us in 2022. And first of all, we did a FOIA because we needed to show that she came in, even though she came in with somebody else's passport. So we're able to show, we did a CBP FOIA, we got her fingerprints, we're able to show that that was her with a different name and a different passport. So now we had proof that she came in. So now the issue was getting the forgiveness for the immigration violation, right? And so we filed a 601 again for her because her previous attorney that filed the 601 denied it. And these are the notes I entered when I entered the notes when I reviewed her case. I said the issue was whether she was inspected. Her attorney submitted a brief saying that under the matter of Queen Lantern, she was I-485 and I-601 were denied because she had no proof of entry. We have CBP for it that shows that she was inspected under a false name. Also, I reviewed the 601 and the attorney brief, and it was poorly done. The clients, whatever the attorney did was just bad work. So we undertook the case. Like I said, we got proof that she was here under a different name, and then we filed the 601, and it was a compelling case. We gathered all the information needed to show that this woman deserved the discretionary grant of a waiver, and the waiver was granted. Yay! This is the second time the waiver was being filed. Second time was filed by us, so it was granted. And then we filed the I-485, and then, of course, we were able to show them that she entered with a different passport and all that. So her green card was approved. And I think she came to pick it up a couple of weeks ago. So since 2014, this is literally 10 years. That's when she's been trying to get a green card. And thankfully, she trusted us to be able to help her do it, and we did it. So I was really excited. So let me answer a couple of questions, and then I have to get going. So, hey, James Tay, how are you? Thank you for joining. Chef says, my I-360 was expedited request was approved. How long does it take to get a decision? I really can't tell you, Chef, but if it was approved, then hopefully soon. Typically, if you're looking at decision, I suspect you mean your I-485. In my office, we've seen anywhere from 3 to 6 months to get the I-485 approved after the I-360 is granted. But sometimes it takes less, sometimes it takes more. So, hey, Alaji says, best attorney, how are you doing with your wonderful team? We're great. Thank you, Alaji, for asking about us. So, Alaji says, how long can you stay outside of the US when you travel with advanced parole? Alaji, you cannot stay for too long because advanced parole is a brief in and come back in, out. If you travel for, I'd say a month, you should be okay, but you don't want to go there and be there for a long time because that's a problem, okay? MK says, dear attorney, since you are dealing with successful VAWA cases, do all witness letter gets verified by USCIS either by calling or home visiting, or have you had any case? Had you had any case with this issue? Well, MK, I can tell you that USCIS will verify affidavits. They do that. And I had a case where we had a landlord that that wrote an affidavit on support in for a client, and I think it was a VAWA case, and USCIS called. Do they call for everybody? No, they don't. But if there's something about your case that makes them suspicious, they are well within their rights to conduct a fraud investigation, which can be calling the people who wrote the letters, showing up at your office, showing up at your home, and who knows, but their fraud unit is very busy. I can tell you that. And then MK says, do you also have to have witness letters attached with I-360 in order for approval, or have you had any of your cases approved without it? I think you mean affidavits. Typically, MK, we really go full force with all our evidence in our cases. So it's very rare for us not to get an affidavit letter. However, I wouldn't focus so much on one evidence as much as what else do you have. So like sometimes you may not have one thing, like if you're a VAWA victim and your spouse has, basically isolated you, you don't have any friends that are not his, you can explain that. There's no bright line rule in VAWA cases. It's credible evidence. So a lot of times when we get cases, we look for what good evidence we have. And if we don't have certain evidence, we explain why we don't have it. And, and then put together a package and a powerful cover letter. That's what we do. Thank you, Sam, so much. I'm going to go to Instagram and look for questions to answer. So someone says, can someone file for asylum after the 1 year has passed already? So Dwayne, that's actually a great question, because for some reason, for the past 2 weeks, I've been seeing people come to my office. Somebody has filed an asylum petition for them like years after they came in here. Now, the rule is that if you're going to file asylum, you have to file it within 1 year of coming into the United States, except you have exceptional circumstances, right? So if you file your asylum petition after 1 year and you don't have exceptional circumstances, like truly exceptional, which means that something happened just now that makes it impossible for you to go, you're going to be referred straight to immigration court for deportation proceedings. And chances are, most asylum cases are actually referred to immigration court, but if you filed your asylum case after a year, that would be a problem if you don't have exceptional circumstances to help you. All right. And so basically filing that, really all it does is, put you in the deportation proceedings. So you want to be careful about that. And you want to be careful about attorneys who are filing these cases when you've been inside the country for more than 1 year. There's some people that just file some frivolous cases, and you need to be careful with them because, like I said to you guys, when you decide to retain an attorney, you need to do some homework on who the person is, the kind of work they do. And if you meet with them and they're encouraging you to break the law, that really pretty much tells you that they're, this is somebody who, this cannot be their first time, and they may already be under USCIS surveillance for filing stupid cases. So be careful. And then, right, Fresh says, yes, very true. Higher accredited attorneys. There's been a recent bust on a Ghanaian attorney filing fake VAWA applications in New York from 2016 till now. That's not a lie. There's always, USCIS is always busting either attorneys or even notarios who, or this immigration preparers who file fake cases. So you really want to make sure that you're aligning yourself with honorable people, honestly, because even if you have a great case, their reputation may just bring you down, all right? And like I said, when USCIS goes down that rabbit hole, it's not fun. So I am Yolanda says, if my husband is approved in his interview in Jamaica, what are the next steps? Also, can he come to the US and return to Jamaica soon? So I am Yolanda. That's a really great question, and congratulations that your husband was approved. So typically once they approve you, they hold on to the passport until everything is done, and then they have you come pick up the passport and all that. Now, what your husband will have is the green card approval, but he doesn't have the green card. So he does need to come into the United States. He must, and he has to come to the United States within 6 months of his approval. And once he comes here, yes, he can go back to his country once he comes here. So now, if he doesn't get his green card by the time he's ready to leave, he can go and just get a stamp on his passport that allows him to travel back. Because some people, it takes a little while for their green card to come, like a month, 2 months. And if he needs to go, he can go, but he just needs to do what needs to be done. But like I said, he must come into the United States within a certain amount of time. So Brina269 says, how does a virtual marriage work? I want to bring my fiance over to the US, but we never met in person. So Brina, first of all, you must be a US citizen to file a fiance visa. And secondly, if you're filing a fiance visa, there's a requirement that you must have met your fiance at least once in the past 2 years. So if you haven't, you can't. Now, there's some exceptions, but they're very stringent exceptions, and people never meet those exceptions. So I'd say if there's a reason that you cannot meet with your fiance in person, talk to an attorney. But if there's no reason, you need to go meet them if you want to file a fiance visa. And if you're going to meet them, maybe you should just get married and file an I-130 petition, because that might be better. There are pros and cons to filing a K visa versus I-130. Like if your fiance has children, then a K visa might be a better way to do it, because they can come together under the same petition. But if they don't, then maybe the I-130. In terms of time, there's not an appreciable difference in time, but K visa is a little faster, just a little faster. All right. Right. All right. Let's see. So Chika says, do you do adoption process for minor? The grandma wants to adopt my minor son. Adoption process is family law, so you might want to talk to a family lawyer. And there's a little more information that I would want to know, because you want to make sure that the adoption process is the right decision, because I'm not sure why a grandma wants to adopt your minor son. But like I said, talk to a family lawyer and also talk to an immigration lawyer that does adoptions, okay? There's certain rules that need to be followed. So Sydney Kelly says, how long can one file for citizenship after VAWA? 3 years. One of the perks of VAWA approval. So if you get your green card through VAWA, 3 years later, you can file for naturalization. Congratulations on getting your VAWA approved. Fresh says, nothing like getting a great attorney who knows exactly what they're doing. I tell you, Fresh, no lies about that, because immigration is such an evolving area of law. You know, things change, and attorneys who are committed to their clients are always trying to stay on top of what the news are. We're learning every day. We're going for conferences. We're doing CLEs. We're chatting. We're in group chats. You know, exchanging ideas. You know, those are attorneys who really are committed. And then there are people out there who are just taking advantage of immigrants. You know. So Marcel Louis says, in the affidavit of support where it asks for tax returns, will they penalize you if you've only been working long enough to have 2 previous years instead of 3? So Marcel Louis, well, you're supposed to send 3 years, right? However, it's the last year that you're supposed to submit. So if you are, you just basically have to explain why you didn't file taxes the 3rd year. For a lot of people, they're not required to file because they didn't make enough money. But the last year, you have to make enough money. And if you have any doubt as to whether your affidavit of support will sustain the I-485 filing, talk to an attorney. Maybe you need to get a joint sponsor. All right, what time is it? 1:28. Okay, guys, I'm going to answer one more question and I got to go, but it's been fun hanging out with you guys. I have an I-130 petition. I'm a Norwegian citizen. Can I switch my consular process to adjustment of status and file I-485 and send receipts of my pending I-130? If you're here in the United States, yes, you can change. Generally, you can change to adjustment of status if you're already present in the United States, James. All right. But I would suggest you talk to an attorney because, like I say, every case there are nuances and want to make sure that you're covered. So my lives are not legal advice; it's just information. So you always want to reach out to an attorney and let them know the specifics of your situation. All right, guys, thank you. And it's 1:29. I have to head out, but pleasure talking to you guys. I'm going to try to come in twice a week now, so maybe Tuesdays and Thursdays. So don't forget to follow me, like, subscribe, and share this video if it was helpful to you. All right, take care. Bye-bye.